such a pleasure to be invited to this webinar and then to speak to you about the do and don'ts, or kind of a demystifying the IP strategy considerations for startup companies. A little bit about myself. I am a PhD chemist. Got my PhD from Tulane, and then worked in the industry for about 4+ years as a medicinal chemist after my PhD. Switched to patent law about 18, 19 years ago, and then started in Chicago, got my law degree there, and then moved to the West Coast at the beginning of 2012. And then I've been with the firm, a big life sciences firm that is well known for representing life science startup companies, Wilson Sonsini, for about 8 years, and then joined my current firm, Procopio, 5 years ago. I work exclusively with startup companies almost. Because that's just my passion. To me, there's a lot of activity, a lot of the innovation, especially nowadays, are driven by startups spinning out of the universities. So to me, I think this is really where all the innovations are started and also developed into the clinics. We still have the big pharmas that is doing a lot of commercialization, late stage clinical trials. But in terms of making true groundbreaking discoveries, and then the early stage development, including phase 1, phase 2 clinical trials, I think the emerging growth companies is shouldering the heaviest load. I have a very deep connection with the ecosystem. I have a lot of VC clients as well. So I do kind of in a VC investment deal, I do deals on both ends. And to me, I think it's important because a lot of the times you really need to look into the future and then think back at where we are as a startup company, and then what we need to do at this moment, with the goal of securing financing 2 years from now. What kind of round we're raising 2 years from now? What kind of round we're raising 5 years from now? And that goes along with a lot of business considerations in terms of what is the R&D going to look like within the next 2 years, 5 years? What is our regulatory strategy going to look like 5 years or 7 years down the line? So those all will tie together, as you will see later in the presentation. I also work with incubators, accelerators. So basically, I think it's very important to be well connected within the ecosystem to really help the company move forward. And then in terms of practice areas, my technical background is organic synthesis. So I do a lot of small molecule therapeutics, large molecule therapeutics, but also do a lot of formulations. So 505(b)(2) companies, and then medical device companies, and then recently, precision medicine is really, I think, a key driver for the future of our life science. Regardless of whether you're doing it now, at some point, I think the precision medicine component is going to be a part of each company's key strategy moving forward. So I've been doing quite a bit of work for those companies as well. By the way, I know that this is not being that webinar, it's not a fully interactive, but feel free to raise questions in the chat. I'm checking it constantly because I want to make it as interactive as possible, because I think through those discussions, we can really further expand the topics. And I think that is what's really important, because I want this to be a little bit more customized based on the topic. All right, so I think we'll start with a general kind of a background. I think a lot of you already know this, but I just want to emphasize a little bit about the forms. And then in terms of startup companies, what's really important. So really, the IP, intellectual property, for life sciences companies, generally four components. You have patents, you have trade secrets, you have trademarks, you have copyrights. So you can see the size of the font. So patents is really dominate throughout. So if you're thinking about the valuation of the company, and then if you're thinking about raising fund, patent will always dominate the IP topic. And then the next in line is trade secret. And then trade secret is also important, especially for AI-driven precision medicine type of companies. A lot of those will be trade secret, or if you're a company that is really the product is software as a medical device, SAMD, then trade secret is also a big part of it. The real tension is, as you will see in the next slide, or the one after, is patents. One of the requirements of the patent is to describe how the invention is practiced. And then by describing it, you're really, you can't keep it as a trade secret anymore just because of its, you have to keep it secret and safeguarded in order for it to be effective. So there's a tension between the two, but the idea is to carefully plan the things, the protection strategy, so that a company can have both. You can have the patents protecting median or more general level of the inventive idea, where the key parameters, especially, for example, for process, or maybe the algorithms for your AI engine, those will be kept as a trade secret. Software most likely will be kept as a trade secret. And then we'll discuss more in later part of the presentation. So trademarks and copyrights, those were less important for startup companies. They're very important for a well-established company or a company that has identified potential kind of third party coming into the field with a similar name. It's still important to exclude those. But for the sake of this discussion, we'll focus on the patents, and then with some discussion on trade secret as well. Okay, so the role of the patent in business, I think it's very important to keep that in mind always, because startup companies are, in the life science space, is quite different from the big tech companies, Apple, Google. They amass thousands of patents. It's just not realistic for life science startups. And then the patents, the role of the patent is also very different. The tech companies, there's a lot of cross-licensing. An iPhone will have hundreds of patents in them, each from, not each, but they most likely they're from different companies. So there's a lot of cross-licensing, and then the more patent you get, the more chips you have, and then you will get a different kind of position in terms of those cross-licensing deals. For life sciences companies, it's very different. We generally create the entire value of the company is in the innovation. So the company will provide products or service sometimes, and then to satisfy the customers' needs or patients' needs in the medical field. And then the products will include technical features that allows the product to be superior than earlier generations, whether it's a lower cost, whether it's the efficacy is better, or maybe just expanded the capabilities of that in that space. Either way, the new product have to have a competitive advantage over other companies. And then the patent, really, what patents do is they create a zone of exclusion. So once you have that product with the competitive advantage, and then if you have the patent that protects or excludes others from using that those technical features to achieve those competitive advantages, you created this zone of exclusion. And then what we call meaningful exclusionary power. So others will not get into your space, and that allows you to raise funds. So a little bit more on that is really how to align the business strategy with the business goals. So for life sciences startup companies, I'm pretty sure those are the two main things that is dominating on the company management's mind. How can we secure financing? Whether you are very early stage, just spinning out of the university, we need probably a lot of those will be funded by the funds, SBIR and other funds. And then at some stage, you will be seeking venture financing. Could be an angel round, could be a Series A, but then secure financing is really the driving force of life sciences startup companies. And then the other key business goal is really our exit strategy. Do we want to develop this product into the clinical stage? Maybe there's a clinical, phase 1 clinical trial exit strategy, and then those are more likely to be a partnering deal with a bigger company, but not necessarily a big pharma. And then there's another one that is more likely a phase 2 clinical trial exit strategy, and then that's where a lot of the big pharmas will be interested in. They will carry on the phase 3 and then the commercialization of the product. So with the business goals in mind, then we look into the patent strategies to enable the company to achieve those business goals. So first of all is the protection of your product. Like I mentioned before, the patents are exclusionary power. So you can, by having a patent that covers your product, nobody can, first of all, kind of just copy it, right? You have the copycats ready to come in. And also you will need to prevent, generic companies down the line. If the product is successful, the generic company can also launch the generic versions of it. So what we need is that your patent portfolio should have very focused protection of your product, whether it's a composition, you have the therapeutic use, you have the manufacturing method, or if it's commercialized, then you also have the commercialized product kit or instructions, patient stratification. There's a lot of ways to protect the core product. And also something to think about is layers of protection. And then that goes hand in hand in terms of where the development is. So at the very early stage, we don't even know what the product candidate looks like. Maybe it's a general platform technology out-licensed from the university. So that will be the first layer. But then how do you construct different layers afterwards, depending on the result of the R&D and product development. So we will in general, you will have broad protections, most likely on method from the university. And then you move, the company will then drive forward, narrowing down the product candidate. So that's what we call a kind of intermediate layer, including things like PK, what is the general indication? So that's the intermediate layer. And then there's a more specific protection. Then that really is the specific product, the compound, the antibodies. And then the more specific indications, because at that time, the company is probably already IND is secured and ready to start the clinical trial. So the specific condition is already available. And then with the layers of protection, also, we will see later on patent expiration date is also a very important consideration for life sciences company in terms of planning their IP strategy. So we'll have to be able to construct patent portfolios such that you can always extend the patent term way beyond the initial invention out of the university, so what we call life cycle management. And then the other big part of the patent strategy is, again, like I said, to block out the competitors. So we'll have to understand, who else is out there. Maybe it's a related group in another university, but they could spin out of their technology and then start their own company as well. And then maybe others. And then with the exclusionary power, we protect our own product, but also we should think about excluding others. First of all, we want to exclude the copycats. When they look at the company's patents, and then they say, okay, how about we also develop our own product, but by designing around it? So that's a concern, a design around. And also, there are companies that really, they're not looking into our technology to develop their technology, but they just happen to have a technology that is within the same space, not necessarily close to ours. But if we have broad claims, then we can have another potential revenue stream, which is through partnering. So we can still develop our own product, but we can out-license our broad patents to another company that is not closely related to ours. So there's a lot of different uses in the broad patents protection as well. Okay, so a quick summary on the business issues guiding patent strategy. So when you're talking to your patent counsel, those terms should always be the focus of the discussion. Let me just admit, there are still people coming in. If those are not mentioned during a discussion, then something is kind of off where we should be in terms of thinking about patent strategy. We have to think about what is the target product and intended use. That goes hand in hand with the patent protection, because things change. There could be a product candidate during the early stages, but then later on, the company may have moved away from that. And then the patent strategy and patent portfolio even needs to be tailored accordingly. We may need to abandon some of the patent filings because there's no use. If the patent doesn't cover our product and then there's no license play, then why spend money on that patent? Because it's just simply a cost item. And then intended use as well, indication may have changed. And then, who are the competitors and what they're doing? Again, that goes back into the FTO, freedom to operate issue, and then to create your space so that the VC investors can comfortably invest, because they don't want to see a company having a wonderful product and then a competitor could come in and then just invalidate that patent or design around patent and come up with similar products. And then which group of the investors is the future IP due diligence review? That's very important as well. The investors could be a partner, in which case then they will look at things very differently. In the early stage versus late stage VCs, they also look at your patent strategy very differently as well. Early stage is more about broad protection. They want to make sure that they invest a relatively small amount, but the company will use that money to go to complete the product development, but also allows the company to go to the later rounds, setting up the phase 3 clinical trial. So for that, they need to make sure that the patent protection is broad enough so that no others will come close to the company, and so basically dominate the space. The later companies, the later VCs, if you're in Series C or D, they don't care about broad protection. They only care about, is there a composition patent that covers the product, and then when does it expire? So the life cycle management really dominates the later stage VC investment, because they know at that time basically no one is going to catch up with the company, because anyone who has been who needs to do something in that space, they need to start about the same time. Otherwise, they're really lagging behind. It's very difficult for the competitors to succeed. And then, but in order, their main concern is the generics, not a competitor in the same space. And the generics, it's all about when is the last expiring strong patent protection of the product. And then exit strategy, like I said before, that will always, sometimes they will change. Maybe it's a phase 1 exit strategy. Now it's changed to phase 2. Maybe the exit strategy is, okay, let's just find a good partner at this stage. And then, that partner we have a very strong technology that complements with our company's strategy. So it's going to be could be a joint venture kind of play. So there's a lot that just the patent strategy needs to be constantly updated in light of the business issues. A quick overview of the patent system. So a patent, again, like I said, it's a right to exclude others. But that doesn't mean that this company, we are free of patents of others. So think about, if you're swimming in the ocean, your patent created this bubble of protection that you can comfortably swim within that bubble. Nobody else can come in because it's the exclusionary power. You have built your own space. But that doesn't mean this bubble doesn't exist in an even bigger bubble built by others that is before you. And then, so that's always a key concept to keep in mind. Having a patent doesn't mean you can protect this technology. You can exclude others from using your invention, but your invention could also be excluded by other third-party patents as well. A second key consideration, obviously, is the term, 20 years from the filing. And then depending on when you file, if you file a provisional application, then it could be a 21-year, because there's a 1-year anniversary for filing the formal patent application. The third one to consider is it's jurisdiction specific. For protection in each individual country, then you have to apply patents in those countries. And then the enforcement is only limited to within the country's borders. And then that could become very expensive. Outside of the US, the patent prosecution, then you're thinking about, translation costs. You have to hire patent attorneys from those individual countries to help you secure patent rights in those countries. So there's foreign associate costs, and it just keeps adding up. So how to solve the problem of, we want to have broad protection in a lot of major market countries, we call it, but also avoiding this cost issue. There are ways to do it, which I will mention a little bit later during the presentation. But the US and ex-US patent protection strategy, I think it's going to be very important for the company's cost concern as well. The last one is that, the patent diversity is an absolute protection. This is the fundamental difference between patent and trade secret. Doesn't matter if a competitor came up with invention independently. If you get the patent first, it can be stopped. For trade secret, they can come up with the same invention as long as they do not misappropriate. For example, they do not hire your company's scientist and then basically just get the invention through that. Then you cannot stop them unless there's a really what we call foul play. Then you can use trade secret to stop them. So for patent, there are some key criteria a company has to meet in order to get a patent. So a lot of countries, each country will have a slight difference in terms of their requirements, but all countries, I think, will have those four general requirements. One is the subject matter eligibility. So there are most of the things, 99% of the things are patent eligible, but there are exclusions. And sometimes the exclusions are important in the life sciences space. We'll talk a little bit more later on. And then the patent, it has to be new. So it's a novelty requirement. It has to be inventive, even if it's new. It has to be inventive or not obvious. So basically, it means you cannot invent something just by combining or mechanically combining what is already available, or you cannot secure a patent by taking an earlier invention and just make a very easy modification to it. Again, whether it is obvious, it's a function of time. When something is at the early stage of a groundbreaking discovery, it's easier to establish obviousness, because if you're looking into this space, then there's not a lot within that space. So you don't have a lot of things that you can use to combine, you can use to modify. But then the later stage, when the space is really crowded, then that what we call prior art space is also becoming more and more crowded. So establishing non-obviousness is going to be more difficult when the space is relatively crowded. And the last requirement is you really must describe to the world how to make and use the invention. Again, like I said, there's this tension between patent and trade secret, but the key is you have to understand the technology good enough so that you can identify that median level to divide the technology into a more like a general protection of the inventive concept versus the specific things like algorithm, things like process parameters. Then you can have those as a trade secret. There's a question, does prior art include patent art that has expired? Yes, I had the exact same discussion with the company yesterday. So her technology has been got out of the university. She was the inventor and she was listed. University filed the PCT that was never converted into any US or ex-US patent. So that's gone. And then she's now interested in actually developing the technology herself, and then started a company, and then saying, can we still capture those earlier broad claims? Fortunately, you cannot, unless, of course, if the earlier expired patents, they do not contain enabling data. So there's one way to do it, which is to say, yes, this is an expired prior art that discloses the invention, but really it does not have data to support. It's just merely a wishful thinking. So that's a line of a position to rely on in terms of reapplying basically for that patent. But it's a very risky strategy, rarely used. Most likely it's about, okay, this is expired, so it's prior art, but also it's a prior art for everyone. So at least no one else can get it and then use that to exclude our technology. So it's a matter of then looking at our technology and identify new ways of protection. So we can discuss a little bit more later on. So let's move on to the subject matter. Like I said, pretty much anything can be protected. You know, the old word from the patent law is anything under the sun can be patented. So things for the life sciences companies, that's compounds, composition, device, all kinds of things, the kit, assays, manufacturing, even software and hardware, they're not excluded, but just rarely people protect software nowadays. They almost always goes under the trade secret. Hardware can be protected. The circuit the diagrams and things like that. And then the exclusions are generally three things applicable to life sciences space. So you cannot patent law of nature, and that goes to some of the diagnostic companies. If it's a correlation between a analyte and a disease, and then that if you are just claiming that correlation, then that's a law of nature. But then there are ways to add a little bit more to take it out of the law of nature, add a little bit more specific technology. Maybe, in order to get that analyte, you have to prepare some kind of a reagent, and then the combination of the reagent and the analyte, then it's a different thing. Doesn't exist in nature anymore. There are other ways to get around it, but just think about this as a key. If your company is a diagnostic company, and then the exclusion needs to be considered and how to get around it. There are ways to get around it, but then how to get around it with the meaningful patent claims to keep the company's value. And then the second one is natural phenomenon. And then for that, then that's really the natural product. It's difficult to maybe there's a, separated is different. Maybe get the enough quantity of the product is different, is challenging. But the key is that we cannot patent the product itself, but there's a lot of ways to patent, still provide meaningful protection. It could be a composition, formulation kind of protection. It could be a product, but then it's with a certain purity that doesn't exist in nature. And then, so final category of the excluded subject matter is abstract idea. So things that you can conceive in your mind. So that goes into a lot of the software space. The second requirement is novelty. So this is relatively pretty straightforward. So it's one single prior art, one reference, teaches exactly what the claim is. And then this is important. When we talk about patentability, novelty, we're not talking in general the invention that is described in your patent application. You really see laser focus on the claims. So really, you're just taking out of your claims and then break the claims down to different components, like on the right side of the screen. And then you look into one prior art that shows exactly each and every one of those technical features, and then put together in exactly the same way as recited in the claim. Maybe the claim doesn't recite any specific ways to put them together. So that's fine. But if the claim says there's component A, then it's electrically connected with component B, and then both components were put into the component C as a shell, then the prior art has to show not only component A, B, and C, but exactly as how they are connected and how they are housed So that's the novelty. Basically means that it's almost an exact match to your patent claims. And then the second requirement, this is more common. A lot of the patent fights between the companies and the US Patent Office, the examiners, are obviousness. So because technology spinning out of the university, generally it's something new. A lot of those are based on manuscripts to be published, and then the professors, they know the space well, and then so facing novelty challenges is less common. And then if it if there's a novelty issue, it's easier to handle, but obviousness is difficult. The reason being, the general standard is that there's prior art that is everything that is published before the application date. So this is what they call a prior available, and then they have this hypothetical person, which is sitting behind the desk, is the person of ordinary skill in art. So in generally in the life science space, it's defined as a master's degree. But then again, depending on the field, it sometimes could be a PhD, sometimes could be a bachelor's degree within the space, and then sometimes with some industrial training, and then in medicine or chemistry or whatever. So they will define this general person of ordinary skill in art. And he has all the prior art available, like on the walls or different journal articles. And then his idea is to pick the ones that is relevant, and then see if there are ways to combine references or modify references so that the modified product or the combined product of the prior art matches with the claims. So it's the same as novelty, but then there are some ways that this person of ordinary skill in art can do in order to get there. Two examples, like I mentioned, one is the combination. So if we have multiple pieces of prior art that if you combine them, have all the elements, and then this person of ordinary skill in the arts would be able to combine them, then the claim is obvious. And then again, the main issue here is that what is the rationale to combine? Maybe those two prior art articles are not compatible with each other. One specifically says that this has to be operated as a aerosol formulation, for example. The other one said, this really needs to be a IV injection. So yes, you combine them can lead to a product that matches the claim, but really those two references, they are not combinable. And then there are also issues of, even if you combine, does it truly teaches all the technical features in the claims? So there is a lot of analysis going into the combination method of the obviousness. The other one is modifications on the right side of the screen. So if one prior art, or could be a combination of prior art, almost teaches everything, but then there are still elements missing. And then does one prior art, the primary reference, have enough motivation to add that missing component, so make that modification to get the invention? So that's another kind of a general way an examiner could reject a patent claim, is through this modification method. And then there are a lot of ways to counter argue. Again, you have to have a rationale to make that modification. And a lot of the times, if you have unexpected results, then you can counter that by saying, if this modification, there are many ways to modify, not just one way to make this particular modification is unexpected, because we have the unexpected result coming out of this specific modification. And then one quick example of non-obviousness is the light bulb. So if there are three papers, one teaches the glass bulb, the other teaches the gas, inert gas, and the other one teaches the electric wires. Can we just combine them into a claim that recites a electric light bulb? Then it's a matter of, okay, does the second reference, when they teach inert gas, do they talk about the use in the field of lighting, and then the glass bulb, then what's it used for, and then the electric wire. So there are ways to overcome the combination or modification rationales for obviousness, but this is just the general kind of introduction of how this kind of rejection is made. Like I said, a very important aspect for life sciences companies to counter obviousness rejections is through unexpected results. And then I think the companies generally will have a lot of data to provide that kind of argument. It could be a therapeutic effect, superior PK, better efficacy, and then could be a deliverability issue. Initially there's an injectability problem, and then now it's solved through an oral administration. Maybe it's there's a uniformity uniformity issue, and then that's solved by the claim technology. Could be a stability increase. The prior product is the shelf life is short, and then the new innovation allows a much better product in terms of stability. Could be a manufacturer. So there's a lot of ways to show unexpected result, but there's one way that you cannot rely on, which is cost saving. So that's always a losing argument, because in the patent offices or the examiner's minds, cost saving is always on people's minds. People always strive to do that. And then just merely with that kind of a motivation in mind, and then the result is only on cost saving, that will generally not allow you to overcome a obviousness rejection. So with those general requirements, then we look into some more specific kind of a practical considerations for life sciences startup companies. I think it's important to consider the way you file your patent applications. So there are two kind of tracks. One is the traditional track on the left, which is you file a provisional application that is not examined, and then you have 1 year to accumulate more data, and then you file a formal application at the 1 year anniversary. So the term starts at the formal application. So you will have 20 years from the formal application date, and then it delays cost. So because it's not examined, once you file the application, you don't have to worry about it. And then you also consider provisional application because at the time of the filing, you only have very limited data. You really need to add more enabling data to make the full application a stronger patentability position, like we mentioned before, a better novelty, non-obviousness. And then the more data you have, generally, the better chances you have to secure a patent. However, the provisional application in the life sciences space really needs a full claim set. That's very important because there are countries, a lot of the countries actually, have a high standard of the written description. Basically, you cannot just put a to be published manuscript and then slap a cover page and file it as a patent application, because the way you write the manuscript really doesn't tell what kind of claims you're pursuing, what kind of exclusionary power you're trying to seek. So a full claim set is really necessary for provisional applications in the life sciences space. On the right side, then is that you have the non-provisional, the formal application, whether it's US or PCT. PCT allows you to reserve rights for foreign country filings. So again, it starts the 20-year clock right away. And then for non-provisionals, the examination process starts. So there's no longer a 1-year period of cost delay. And then PCT, however, the international patent then can further delay the cost for another 18 months from the filing. And then for the formal application, then you have to have the full specification, all the descriptions, the full claims, and all the data. So once that is filed, no further changes can be made. And then the typical timeline for the non-provisional PCT, traditionally, it's 2 to 4 years, just because there's a long queue at the patent office. And then for the PCT, then you have this other additional 18-month delay. So it's a slow process. If the company, the need of the company is really to secure patent sooner, then what do we do? So this is a program that has been very popular, and I think it's very important almost for all of my life sciences clients should consider this track 1 examination in the US. So basically what it does is that you pay a small amount of fee. Most likely it's about $1,600 or $1,700 for small entities. And then what the USPTO promised is that within 12 months, then you can go through 2 rounds of back and forth with the examiners. And then based on my recent experience, generally you will hear from the patent office within about 3 to 4 months. So basically, if you file this patent, instead of a provisional and then wait for 1 year and then wait even longer, up to 2 or 4 years, to hear anything back from the patent office, you will hear something about your invention. What's the prior art? What's the kind of a likelihood that you will get some issued claims within about 3 to 4 months? So that's important, especially if a company is trying to talk to VC for some early rounds, right? There's an angel round. There are investors that want to know if I invest, will you get good, sufficient patent protection? If you have one provisional application, your answer is going to be yes, we filed a provisional application, but we won't know until about 2 years later. That may not be sufficient for the earlier stage investors. Like I said, they want to make sure their funding, the money they invest is good enough to carry the company forward. And then without knowing that they have an issue, they can have an issue patent to exclude others in the space, then there's always a risk of their investment. So another good aspect of this track 1 examination is that once you can hear from the patent office quickly, then you have a lot of intelligence on the patent landscape. Who has filed what in this space? Who are the other players? Then you can have that intelligence as well. And then you can, again, on the US side, you kind of accelerate it, but then you can use the issued US patent as to leverage and accelerate foreign prosecution. So you save a huge amount of costs in prosecution patents in China and Europe. With all the translation and other costs coming in, you want the foreign application process to be as short as possible. And having an earlier issued US patent really goes a long way in terms of achieving that goal. And then basically for the, in general, so for the life sciences patent strategy, kind of platform inventions, we generally just take the fast boat approach, file the fast track 1 in the US. we accelerate the prosecution in the US using examiner interviews, and then get a US patent quickly. So I've done about at least a dozen track one applications for my clients, and a majority of them issued within 7 to 9 months. So 7 to 9 months after you file, you already have an issued patent, you can show it to the investors. That goes a long way in terms of secure your financing. And then you can, like I said, you can leverage the US allowance and issuance internationally via what we call patent prosecution highway to save costs. And then for the product specific dimensions, then it's about, further extend your patent term, right? But then you can file the provisional, and then you can file the non-provisional, so that cost will be delayed, and then you can have one additional year of the patent term because you filed the provisional. So there are a lot of specific strategies that allows us to achieve different goals, the fast boat approach and slow boat approach. And then the last topic I want to touch is the danger of pre-filing disclosure. That's a lot of the earlier startup companies stumble onto this issue, and then if not handled carefully, it will become a showstopper later on because what we call absolutely novelty requirement. So if you publicly talk about it, poster, you do a presentation at a conference, then that could have impact on your ability to secure that patent filing if it's filed later. If the patent is filed before the public talk discussion, the poster presentation, then you're fine. But if you're thinking about discussing it first and then file the patent application, you could run into big trouble. There are some exceptions, but in US and other countries, but it's not ideal. So really the best way is to file before you publicly disclose. And then that also includes when you disclose it to the VCs. NDAs are great, but the NDAs have their problems as well. Those are more specific issues that I'm happy to cover in another webinar. Actually, this is the beginning of the general webinar, but I have quite a few others. So if there are interest, we can expand on a lot of the subject that we already discussed about the life cycle management and different things. But here's just I think it's worthwhile to raise the alarm so that you know that this is pre-filing disclosure is very dangerous.